Marshall. Madam Chief Justice, and may it please the Court, Robert Shaw, I'm privileged to appear today on behalf of Eddie Vallejo. Separate and apart from the GPS sentencing issue, which I hope to get to in a few moments, this case gives rise to three issues which we ask the Court to look at individually and in combination, all of which derive from the fact that this was a joint trial. And those issues involve the co-defendant's closing argument, the co-defendant's statement which came in through a detective, despite the fact that the co-defendant was not testifying, and the co-defendant's persistent focus during trial on his waiver of constitutional rights as a reference point for assessing credibility. And the important context for these issues is that we have a co-defendant who really pursued a he-did-it defense. He literally accused Mr. Vallejo of assaulting the complainant, and he utilized...
How did he do that? In what fashion?
In the closing argument.
Okay. Not in the evidentiary, not in the evidence, not in his statement to the police that was admitted.
I think it's fair to say that during the evidentiary portion of the trial, the evidence was fairly neutral. And then when it came time for closing argument, it was the statement that he made to the detective and his assertions of credibility that really served as a platform for his outright attack on Mr. Vallejo.
It was explicit in the closing argument, wasn't it?
Very explicit and repetitive through the closing argument.
But in his testimony, all he essentially said was that they were tickling her and that she was mad when she left the car.
Whose
statement or testimony?
Mr. Gomez's.
Statement.
Mr. Gomez's statement. I'm sorry. Mr. Gomez's statement was simply that they were tickling her and she was mad when they left the car, which is just what your client testified to in his testimony at trial.
Well, actually, I think if you look closely at the statement, what you'll see is that the gist of the statement, it goes to the surrounding circumstances giving rise to this alleged touching, and it contradicts Mr. Vallejo because his entire case was that essentially he was unaware and uninvolved, and Mr. Vallejo's defense, which was focused upon the fact that everybody was involved, these were kids who were in the back of a car, they were joking around, there was laughing and tickling, and that if some sort of touching occurred, it was accidental. His entire defense was that he was unaware, uninvolved. There wasn't this involved, shared horseplay that was taking place. And the critical thing is that that statement was the platform from which he launched his defense.
But he said they were tickling her.
Well, if you look at his statement...
I have.
Okay. And his defense is that he was unaware and uninvolved.
But Vallejo's defense was he was unaware.
This is Gomez. Vallejo's defense was that everybody was involved with this. We were all tickling. We were all joking. These are the surrounding circumstances. Now, whatever the Court decides with respect to the first two issues, I think when it gets to the closing argument, when the Court looks at the standards set forth in the McAfee case, it's very clear that
Wait a minute. Let me try to get it exactly straight. Vallejo said that they were all tickling and all involved.
The surrounding circumstances is that, they're in the back of the car, there's joking, tickling going on,
and
shared horseplay.
Right, and your client he's unaware that anything's going on.
No, my client is...
I'm sorry, and Gomez's statement is unaware and uninvolved. That is his defense. That's his defense. And he utilizes the statement to the detective as, in part... So why aren't those inconsistent defenses from the beginning? Because one is saying, I'm uninvolved, and the other one is saying, everybody's involved. Well,
they are inconsistent, Your Honor. They are inconsistent, and they're inconsistent in a very important way, because the statement to the detective and the notion that Gomez was putting forth, which is that he was unaware, is that statement is really the basis for his defense. And it's a statement which goes to the surrounding circumstances, the immediate surrounding circumstances, and that was very important foundational evidence. So I would say it was inconsistent, but when you get to the closing statement, I mean, there's just no doubt about the fact that these were very hostile defenses. I mean, he is accusing Mr. Vallejo repeatedly, which is something that I think is quite unusual. But
Mr. Vallejo himself testified that he was involved in tickling the alleged victim, and that while tickling, his hand slipped into her pants and under her underwear. So he admitted that he had essentially touched her indecently. He just simply claimed it was accidental.
Well, Your Honor, I think if you look at the record, you're going to see that there's some very troubling inconsistencies in the way his Spanish was translated. But the essence of his testimony is that he did not touch her in an indecent way, and if his hand came down into the midsection area, it was accidental. That was his defense. This wasn't an intentional touching, it was accidental. And that's why Gomez's defense and Gomez's statement to the detective, which ends up accusing him, is so critical. And
did you file a motion to sever before trial?
Yes. The motion to sever was filed. It was argued before trial. It was raised throughout.
But that was a very different basis than what you're arguing now.
Well, Mr. Vallejo's counsel was essentially saying that the information I have is that these are going to be hostile defenses. And the judge at that point in time was not willing to rule in his favor, but acknowledged an ongoing obligation to continue assessing it. And
Well, she excluded some evidence based on the motion, right? I mean, she basically said, I'm going to deny the motion to sever.
The motion to sever was first denied by a different judge, wasn't it?
That's right.
Not the trial judge.
I believe it was the trial judge. It was filed before trial. At the beginning of trial, it was taken up. Okay. It was renewed after the closing argument, of course, along with a motion for a mistrial.
When did counsel for Mr. Gomez, it must have been in the closing argument, make the points about or maybe it was in questioning the police witnesses. He volunteered, you didn't have any trouble he talked to you. I mean, all the things that you're arguing were implicitly pointing to your client.
Okay, the silence issue.
Yeah.
That permeated the trial. It began in opening statement, after which there was an objection. It occurred through cross-examination when there was this consistent emphasis, and then it persisted in closing argument. Okay? But even before getting to that, just if I can touch quickly, the McAfee case essentially says that a co-defendant can summarize the Commonwealth's evidence in a manner that doesn't undermine the other defendant's defense. And it's very clear here that a mistrial should have been granted or severance should have been granted. He was not only contradicting Mr. Vallejo's defense, but he was attacking him. In addition, it's very prejudicial to Mr. Vallejo because he gave his closing argument first. He did not have notice that the co-defendant was going to take it to such an extreme, so he was unable to respond. And then, when you have a closing statement that really casts the evidentiary portion of the trial in a very prejudicial light toward Mr. Vallejo, it's very difficult to look at the evidentiary portion of the trial and say, that this was just a neutral evidentiary portion. Now, with respect to the admission of the co-defendant's statement, there's no doubt that statement was testimonial. And as I've already...
It wasn't admitted against your client.
Well, there was an instruction.
Right?
Okay, there was an instruction.
No Bruton problem. And with respect to whether it was admitted for testimonial purposes against your client, the answer is no.
Well, I would say that there's a contextual aspect to this at the very least, okay, number one, under Bruton. But I agree with you that there wasn't any express accusation in that statement. And it is true that there was a instruction from the judge, but the question is, was that effective? And our position here is that under Crawford, I don't believe that this court can say that we will allow a testimonial statement in that is a critical statement because it goes to the surrounding circumstances, and that it's okay not to have the right to cross-examination because the judge gave a limiting instruction. And that's the point here. And in terms of the effect of this statement, I again just want to emphasize, some statements that a co-defendant makes, it may be quite simple to apply it to one defendant and not the other. But this statement is going to the surrounding circumstances that gave rise to the alleged touching. So it's very difficult to see how a jury is going to be able to only apply that statement to Mr. Vallejo or Mr. Gomez and not apply it to Mr. Vallejo. So,
I don't have Mr. Gomez's statement in front of me, but, it strikes me that they were so close. They both said this was a tickling incident, right?
Right, but Mr. Gomez is, The way Mr. Gomez's counsel was using this was to contradict the notion that there was this shared horseplay. I think that's fair to say. I mean, it is true that these statements aren't perfectly definitive one way or the other, okay? There are some similarities. I certainly wouldn't contest that. But what I would ask the court to do in assessing this is look at Gomez's trial strategy. How can you say that the statement was just similar to Vallejo's when the trial strategy in the closing argument of Gomez was to use this and this notion of being unaware and uninvolved to attack Mr. Vallejo?
Well, I mean, in fairness, wasn't the closing arguments focused to say, how do we explain why this victim is accusing my client, Mr. Gomez, of doing this? And what he basically said was that she was a strong girl. She apparently was she was playing on the boys' football team in Waltham High School, and that what was going on in her mind, he argued, was that she needed justification for why she didn't fight back. That was, I mean, the context was him explaining why this girl would accuse Mr. Gomez of doing what he didn't do.
Right.
That was the focus of why he was going into your client's conduct.
Right. And my position, and what I ask the court to look at when you assess this, is that not only was there this theory that the complainant came up with this idea because she, was a strong individual and so forth, but there were outright, explicit attacks from Gomez to Vallejo through the closing argument. You can look at my brief. They're laid out in a footnote. And it was totally unnecessary. It was totally unnecessary. And, in my career, I've never seen that quite happen. I think that, there can be some inconsistency and some antagonism, but to spring this on closing argument on one co-defendant, last I looked, there was more than a quarter century of legal experience before me on this bench, and I bet my bottom dollar that it's pretty unusual from this court's perspective as well to see these kinds of accusations. I think they were fairly significant. And I think that in light of those accusations, it is very difficult to just view this statement as being neutral.
So what's the court to do if you go to closing argument and the co-defendant decides essentially to maintain the defense to say, this guy may be bad, but my guy didn't join him? And then you have to declare a mistrial?
Well, that's right. And I think that there's a very easy thing to do which can avoid this. And that is that I don't think that a trial judge can prevent Gomez's counsel from taking on this tact in a trial. But the trial judge can require Gomez's counsel to disclose to the trial judge. At the beginning of trial, when this motion for severance came up and Vallejo's counsel said, my information, I want to have a private discussion without the Commonwealth there so that we can discuss defense strategies, Gomez's counsel should not have just sat there and laid back and then sprung it all out on the end.
But that assumes that Gomez's counsel before trial began knew exactly how he was going to close. He had to react to the quality of her testimony and to your client's testimony.
Right. But in terms of this court's sort of policy consideration about how to deal with this, the fact is that there may be cases where, because the evidence comes in a certain way, it is clear that a defense counsel can go to the judge and say, Your Honor, given the way this is unfolded, I feel that it's necessary for me to protect my client to have this sort of antagonistic closing. And the judge will be able to look at the evidence as it came in.
May I ask you, back to the motion to sever, did you make a representation of why the cases should be severed?
Well, Mr. Vallejo's...
Was it that we have antagonistic defenses, or the Code D is going to point the finger at my guy?
Well, right. Essentially, it was that my information in speaking with Gomez's counsel is that these are going to be antagonistic. I don't think it got into too much detail, but the...
Have the transcript of the motion to sever?
Yes. Yes. And just with respect to the silence issue, if I could just address that very quickly, I want to make very clear to the court that I am not addressing the issue of whether in a single defendant case a defendant should not be able to utilize the waiver of constitutional rights as a mark of credibility. That issue is not before the court. And what I am essentially talking about here is that there is a joint trial, and that in the context of a joint trial, when you have competing defenses, when you allow the waiver of rights and the waiver of an attorney to be held out as a reference point for the assessment of credibility, you just can't do that without diminishing the opposite, which is somebody who was, it appears, from the jury's perspective, silent.
Thank you, Mr. Shaw.
Thank you.
Ms. Bynes?
Thank you, Chief Justice Marshall. Good afternoon. May it please the court. My name is Suzanne Bynes, Assistant District Attorney from Middlesex. With me today is also Assistant District Attorney Kevin Curtin. First of all, I would just like to clarify a number of facts, actually, but two very important facts. The first is that Mr. Vallejo's defense at trial was not, we were all involved. I think a reading of the transcripts makes that very clear. Mr. Vallejo's defense at trial was, this happened, but it was an accident. And that was his defense from the very beginning, as compared with Mr. Gomez's defense, which was, we were all tickling, I didn't see anything, I didn't do anything. Those defenses are not antagonistic to one another, nor are they irreconcilable with one another. And I'll get to that.
Well, maybe the problem is that Gomez's defense is inconsistent in itself. We're all tickling, but I didn't see anything or do anything, because if he's tickling, he's doing something, and he saw something.
Well, when I say I didn't see anything, I didn't do anything, I'm referring to I didn't see anything untoward happen, and I certainly didn't do anything to assist in making anything untoward happen. I didn't assist in Mr. Vallejo's hand going down the victim's pants, which Mr. Vallejo took the stand and testified happened. So that, I think that's an important clarification in this case. Also, I'd like to clarify the motion to sever that was filed at the beginning of this trial. The written motion to sever merely says that Mr. Vallejo believes that he doesn't know, Mr. Gomez will testify that he doesn't know what Mr. Vallejo did and couldn't see it because it was dark at the time of the incident. His testimony is likely to cause the jury to see the question of Vallejo's guilt or innocence in light of comparison with Mr. Gomez. That certainly does not meet the severance standard that's been set out by this trial. There was a second oral application for severance that was made on the grounds that Mr. Gomez would bring in evidence of a conversation that took place between Mr. Vallejo and Mr. Gomez, where Mr. Gomez asked Mr. Vallejo if this indeed happened. Mr. Vallejo didn't say anything, and Mr. Gomez wanted to argue that was an admission by silence. The judge precluded that. So at the time, the motions to sever, the grounds for the motions to sever at the beginning of the trial were properly precluded by the judge, and there was no other motion to sever that was ever brought to her attention until the very end of the case. Well,
did the argument at the hearing on the motion to sever, did that go further than what was actually stated in the motion?
No, Your Honor, not. My memory of the transcript and reading that hearing is that it did not go any further. There were no further facts. In fact, the bulk of the oral motion to sever of the hearing was about the conversation between Vallejo and Gomez that was precluded by Justice Kottmeyer. Your Honors, the rule that the defendant is asking this court to adopt in this case is such a radical departure from the existing law as it stands today, one which has no support in this court or any other court's jurisprudence, and also one which is wholly unsupported by the facts. And I'd like to briefly start with the facts of this case. Here, Mr. Gomez made a statement to police prior to trial. He argued, as was his right, because that statement was exculpatory and was coming into evidence, he argued, look, I made that statement voluntarily. I came in, I told the police what happened, and you should believe me. You should believe that statement because I came in willingly, and I looked him in the eye, and I was honest about what happened. There was never any mention by Mr. Gomez's attorney, never any mention of Mr. Vallejo at all.
Well, I don't think that Mr. Vallejo, I can't say it, but the defendant's attorney, is suggesting that it was improper to do that. It's just that it's doing it in the context of having another defendant whose statement has been suppressed has a certain implicit meaning that can't be avoided.
Well, and that I would first I would argue that there's no any implicit meaning is so speculative in this instance. If you read all he argued was his statement was voluntary. If you determine in this case that that's enough,
I went into the police and I looked them in the eye. I mean, sure. You know, I mean, that's absolutely his right to do, but it has consequences for the other defendant. I think that's the argument.
Well, what the logical consequence of that decision, to say that the consequence of that action, to say I looked the police in the eye and I was honest and I was forthcoming, that is sufficient to create an implicit contrast. If that is the ruling, you could never have joinder of defendants in any case, because where you have more than one defendant, if one defendant chooses to take the stand and testify at trial, something you won't know beforehand, they can decide at any point that they want to take the stand and testify. They take the stand, they testify. Their attorney is then precluded from arguing, you can believe what he said. He took the stand. He was honest. He looked you in the eye and he was forthcoming. That's the argument that was made by Gomez in this case. If the question is there a situation that could give rise, could a co-defendant's attorney create a situation where he's actually contrasting his actions with those of the defendant, that can exist. And in fact, I think that case was cited in Mr. Vallejo's brief. It's a Fifth Circuit case of DeLuna where one defendant took the stand. He was pointing the finger at the other defendant. And in the closing argument, his attorney said, an honest man takes the stand and tells you what happened. Now, there you have an explicit contrast. There you have evidence that one person didn't make a statement. Here, Justice Cottmeyer went out of her way to make sure that the jury never heard that the defendant had been arrested, never heard that he had ever been Mirandized. There was never any evidence that he ever even had an opportunity to speak with the police in this case. So there was that implicit contrast. It's hard to get there without speculating, without being too speculative. And if you determine that that is, in fact, a contrast, then, as I mentioned, I think you have a serious problem with any joinder of
I'm not suggesting that by itself it says you need to have a severance, but it is a factor that can be looked at. I mean, I don't think it's an irrational argument for someone in this defendant's spot to say.
Well, certainly, I'm not irrational. I'm not name-calling here, but what I would say is that the trial judge was in a very good position of assessing whether or not this was in fact occurring, and the issue was brought to her attention from a very early point, and she went out of her way to protect the defendant's right, in fact precluding evidence of any statements by anyone in that car. So the prosecutor wasn't even permitted to put on evidence that the police had gone and spoken to the other people in the automobile. Whether or not that was the appropriate ruling, that was precluded in order to avoid any implicit contrast. And so I think that in this case, the trial judge did an excellent job of protecting the defendant. Additionally, she gave limiting instructions to the jury that openings were not evidence, and did the sua sponte exclusion of any statements. But the final thing I'd like to point your honors to is there are no cases. There's the appeals court case of Rousseau, and the test used in that case I think is the appropriate test here, where the Rousseau court asked first, was there any direct reference made to the defendant's actions here? And there wasn't. There was never any reference to the defendant being arrested, Mirandized, or spoken to by the police. No reference whatsoever. Second, was there any explicit contrast made between the co-defendant's actions and those of the defendant? And again, there wasn't in this case. There was no express contrast made whatsoever between Gomez and Vallejo's actions with respect to giving statements. And I don't think it's insignificant that Mr. Vallejo actually took the stand and testified in his own behalf here. So to say that he was somehow prejudiced by the fact that the jury didn't hear about a statement made pre-trial, well, they heard his statement from his own mouth. And finally, if you compare the closest cases I think that you can compare these to are the Doyle, and I'm not sure if I'm saying this right, but the Mahdi line of cases where a prosecutor actually makes a comment about a defendant's fifth right to remain silent. I was unable to find a single case from this court where a violation occurred where there wasn't at least a comment made about the defendant speaking or not speaking. So in Cobb, you have a prosecutor saying, he didn't say he didn't do it. In Haas, you have him saying, I think I have it here. Haas, at no time did the defendant say he didn't do it. There's nothing like that here. So in essence, to adopt the rule that the defendant is asking for in this court, you would essentially be placing a higher standard on co-defendants than you would in situations where there's actually state action. And I don't believe that that is what this court should do in this case. With respect to the motion to sever, there are two issues there. First, the defendant is unable to establish that the defenses in this case were irreconcilable, were antagonistic, and I do this, I trip on these all the time, were mutually antagonistic and irreconcilable. When Mr. Vallejo's attorney was up here, he actually used the word hostile. At closing statements, the defense became hostile. And I think that's important. That's an important word because this court, if it's McAfee or McAfee, I'm not sure what it is, explicitly said hostility is not enough. Finger pointing is not enough. It actually has to be where the situation must be that both defendants are pointing the finger at one another and there's no other evidence for the jury to look to. Here, you had the witness's testimony that the jury could rely on and actually did rely on in this case in order to come to its verdict. So the defendant hasn't met the burden that he needs to meet under Moran and McAfee to establish that severance was necessary in this case. Finally, as to the Bruton issue, the defendant's statement, which was entirely exculpatory, both as to Mr. Vallejo and as to Mr. Gomez, did not violate the Bruton standard, nor was it a Crawford violation. This court, I haven't found a case specifically where this court has applied Crawford to issues of Bruton, but I can tell you that in the First Circuit in United States v. Cruz-Diaz, in the Second Circuit in United States v. Harris, the Ninth Circuit, as well as the California State Supreme Court in People v. Lewis, the Ninth Circuit case is U.S. v. Eldridge. The court found in every single one of those cases that a statement by a co-defendant in a joint trial does not offend the Confrontation Clause where it's introduced as evidence only against the speaker. And that is the right ruling, and that's the ruling, that's the correct ruling in this case. Here, the evidence was never offered against Mr. Vallejo. The statement was never offered against Mr. Vallejo. It didn't incriminate him anyway, but Justice Kottmeyer was very explicit in telling the jury, you're to consider this against Mr. Gomez only and not against Mr. Vallejo. So for all of those reasons, we ask this court to deny the defendant's request to reverse his conviction. With respect to the GPS issue, I know this issue is currently before the court in Commonwealth v. Corey, as well as a number of other cases, and that you've heard it's been briefed and argued. So if you have no questions as to that issue.
I take it it's clear just in the briefs that the judge, the sentencing judge here, imposed this condition because it was required by law.
That's correct. That's exactly what she said.
So just to make clear, it was not in any way a discretionary judgment on her part. Is that what you're saying?
She did not. She determined that she didn't have discretion, that once the defendant was placed on probation, which he was in this case, the statute required that the GPS monitoring bracelet be placed on the defendant. That's correct.
Thanks.
Thank you, Ms. Bynes.
Thank you.